Hi, everyone. Joe Gentili from Saroff Gentili LLP. Today's question is, if you have an application that's denied by USCIS, should you file an AAO appeal? So generally, when you have a petition or an application that's denied by USCIS, you have the option to file an appeal with the Administrative Appeals Office. And generally, I'd say that it's not a good idea to do so. They're not required in most instances. There was a Supreme Court case called Darby versus Cisneros from 1993 that basically said that unless a statute specifically says that you have to exhaust remedies and file an appeal, you don't have to. So in most instances in immigration, you don't have to. Now, what normally happens if you do file an appeal is you're giving the government another opportunity to issue a denial again, which they normally do. Most AAO appeals, they affirm the denial. But now they're doing it with more time, and they're doing it with better reasoning and probably with an attorney as opposed to not an attorney the first time around. So basically, if you've done the appeal, you're going to end up with a denial that is much more difficult to challenge in federal court. So in general, I would say the appeals are not a good idea. If you are going to challenge the denial, you're better off going directly to federal court to do so. You want to challenge them based off the most poorly reasoned denial that you're going to have, and that is going to be the initial one. So that's the one you want to fight. There's an exception to this. So when you file a case in federal court under the APA, which is the law that you would use to challenge a denial, a USCIS denial, the judge will decide the case based off the record that was already created. So once you get to federal court, you can't introduce new facts into the case. So if there were new facts that came up after you filed your initial application, let's say that it's not incorporated in your case, you may want to file an AAO appeal if they're really important facts. So this way you can make those facts part of what's known as the administrative record, which can then at that point be used in federal court. So that's an exception to the general rule, I would say, which is you should skip the AAO appeal and go straight to federal court. If you have any questions, please feel free to reach out. And as always, if this content is helpful and useful, I encourage you to subscribe. Thanks.